If I'm correct, then 91 days after I purchased my Office 365 operating software and I had my concerns regarding the business license situation would have been July 14th of 2020. On July 14th of 2020 at 4:30 a.m., I received a quarterly invoice from PACER. PACER is the electronic filing system for the federal district courts system. It says that the balance due is $35.60 and that it is due by August 10th of 2020. First of all, I have already printed out records of what the charges were the last time I engaged in printing on the PACER system. The day I printed it, they did not appear. So I went back another day and then I printed out the charges up to that day without printing anything else out. And I have those electronic records and they are below what is the balance for printing from PACER wherein one is billed. PACER has a process wherein if you acquire charges below a certain amount, they do not require you to pay those charges. I contend they've artificially inflated this bill in order to make it appear as if I owe, when technically speaking I don't. I have those electronic records. But here's the situation more than that. I have now one, two, three times formally filed, and I have formal filing documents that have been time stamped, both on site, in person, and also electronically time stamped. I have created not only the information that I've not only filled out the forms I needed to and submitted the forms themselves, but I also came up with a appeal to a request to move forward pro hac vis in order to be able to be involved with the legal system in a manner that would extend to me the same sort of professional courtesy and expectations required of other prosecutors and defense attorneys in a proceeding, up to and including a criminal proceeding. For nearly 4 years, I have been denied any access to a prosecutor, district attorney, or attorney general's office. I have two electronic communications with the attorney general of the state of Texas and one communication with the attorney general of the state of California that basically said, we're not going to help you. This is not something we're going to assist you with. And in the meantime, I have been denied any assistance by a district attorney. I've been denied any assistance by anybody from the Department of Justice. In matter of fact, every single time I've encountered them, it appears to be some sort of very sophisticated ritual of humiliation, where the object is for me to be the woman petitioner. Literally. Have you ever read The Bedbug? See, if they were the kind of people who have access to the kind of surveillance that I know they know that I was in a theater group in college for the short time I was in college. And among the things I did was attempt to get casted in a play by Vladimir Mayakovsky called The Bedbug. And then at that time, I was able to be given an actual performance role of woman petitioner number one, right? So I'm woman petitioner. And I've had to go pro se, despite the fact that I presented what I believe to be, if nothing else, a very compelling argument for how, at least for the proceedings that I had presented in the district court here in Dallas, I should be permitted to go pro hac vis, meaning I would be availed of the same sorts of requirements, but also courtesies that any other lawyer who's a member of the bar is. There is no requirement, legally speaking, that I have to have a lawyer. There are plenty of precedents, including at the Supreme Court level, and plenty of opinions concerning pro se representation. But my contention is that going pro se is, on one hand, a disadvantage, but it's also a highly exploited manner in which one proceeds before the court. And amongst that is the fact that I do not have access to things that professional lawyers have access to that can secure themselves against whatever the charges are concerning their clients, A. And B, there is an entirely different field of political capital insofar as they are members of the judicial branch that they have access to and that they use in their proceeding that is not about the best interest of their client, but is about a variety of other capital considerations as well as a variety of other procedural manners in which they move forward. These are not provided to the client. The consent of the client is not obtained in using their lives and the legal process that their life is engaged in as part of whatever the speculation or political economy of members of the judicial branch is. And what's happened is repeatedly, despite me demonstrating cognizance and mental capacity, my filings are instead of actually being addressed for the merits of the arguments, my filings are used in derivative action for any number of other people who refuse to identify themselves, and I've been tracking it for years. So I say, if you're going to say I'm required to proceed as a pauper and that you are not going to make me pay the filing fees, and I say I am willing to present myself and present my case on level with the kind of professional standards other lawyers would be subjected to, including having to address the billing record situation, including having to address the filing fee situation. And then you say you're not going to accept that I'm held to a lower standard because I'm pro se. And apparently that means that I'm supposed to hold you to a lower standard because you refuse to accept me outside of a context of pro se. Then my say that when you say that you've granted me permission to file as a pauper and you've waived all fees, then you've also waived all the electronic fees. And if you, in your professional context, have required me to register with the electronic system, and as a judge or a magistrate judge who is under a presiding judge that's already issued an opinion and a judgment saying he supports you, if you've said, I am not required to pay any filing fees, then I am not required to pay any filing fees with the electronic record system. And that a bill is on you to address and deal with. I've already reported how the manipulation of the electronic filing system, including in consideration of filing fees and bills, is part of this pattern of racketeering activity. You literally sent this to me on the 91st day after my operating software license was stolen by somebody else. Nobody's responded to that. You give me a derivative action, literally using the court's electronic filing system. You've already, multiple times, refused to acknowledge me as your colleague. What you've said is I'm poor, and because I'm poor, I am not required to pay any fees associated with my case. I told you I'd pay the taxes, and I have, but I am not obligated in any way, shape, or form to pay this quarterly invoice. These are not charges that are my responsibility. And the misrepresentation, not only of these charges, but also everything I found on the PACER database while I was actually printing, after it had been shut down for maintenance and the electronic filing records were altered, that's also not my responsibility, because you were the ones that accepted me as a pauper instead of accepting me as a qualified professional. It is 5:16 p.m. on July 20th, 2020.